Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razan Pereira. The government is planning to bring an ordinance to overturn the Supreme Court verdict putting safeguards on arrests under the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act and subsequently introduce a bill to insulate it from further judicial scrutiny. The government is likely to introduce the bill in the monsoon session of Parliament to incorporate the legislation in the 9th schedule of the Constitution, laws under which cannot be challenged in courts. Referring to the proposed bill, PTI quoting an official said, once included in the 9th schedule, the legislation gets protection under Article 31B and is not subject to judicial scrutiny. Recently, the Supreme Court refused to stay its 20th March order diluting certain provisions of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act. On this edition of The Big Picture, we will analyze the 9th schedule and its provisions. Joining me on the program today are Professor Narendra Kumar, School of Social Sciences, JNU, J. Sai Deepak, Advocate of the Supreme Court, and Satya Prakash, Legal Editor of the Tribune. Thank you to all my guests for joining me on this edition of The Big Picture. Let's first try and put into perspective and understand what the 9th schedule is. Sai?
See, the 9th schedule was brought about as a consequence of the first amendment to the Constitution in 1951 by Jawaharlal Nehru. When the Land Reforms Act of at least 3 states, I think Madhya Pradesh, Uttar Pradesh and Bihar, they were challenged and 2 they were not struck down, but one of it, I think of Bihar, was struck down as being unconstitutional to ensure that these legislations which were meant to usher in agrarian reforms are shielded from being struck down by the judiciary. This was the original intention, at least when he gave his speech in the Parliament with respect to these legislations, and when he decided to bring in this particular amendment to ensure that there is no judicial review of these legislations. So the original intent of Article 31B was to shield any agrarian reform related legislation from judicial scrutiny and from being struck down on grounds of unconstitutionality. Now, this was the first amendment. Now, this amendment was followed by then a 4th amendment, and then the 17th amendment, and then the 25th amendment. And this provision underwent multiple interpretations, and the last interpretation, from what I understand, was the one that was delivered in, the most significant one was the one in the Keshavananda Bharati case on 24th of April 1973. Before that, you had the Shankari Prasad case, the Sajjan Singh case, and the Golaknath case. Ultimately coming to the point that legislations which had been included in the 9th schedule until the date of delivery of that particular judgment shall not be struck down and shall be shielded by Article 31B. But any future legislation that is sought to be included in the 9th schedule shall be tested on the touchstone of the fundamental rights and the basic structure doctrine which was introduced. And therefore, the doctrine of prospective overruling was basically brought about, which is to say, protect all legislations which were incorporated as part of the 9th schedule until that particular date, and I suspect it was around 250 legislations around that particular date.
Yeah.
And all future legislations will have to be tested on that particular annual. Now, therefore, the 9th schedule effectively tries to undermine the role of the judiciary when it comes to scrutinizing the let's say the legislation, and the prime mover behind the legislation, if it happens to be the executive, if it tries to circumscribe the scope of fundamental rights. Now, this is more or less the history of the 9th schedule.
Indeed. All right. Thank you for taking us through the short history of the 9th schedule. Now, let's talk about what's happening in present terms. Satya Prakash, why does the government want to incorporate the SC/ST Act in the 9th schedule?
Before I answer this question, I would like to add to what Sai Deepak has said. The latest verdict on 9th schedule was a 9-judge bench verdict in the year 2017, January 2017. That bench was headed by Justice Y.K. Sabharwal. And earlier, as Deepak has already pointed out, it gives notional immunity to laws placed in the 9th schedule. Purpose, he has already said, was to save agrarian reform laws, and that was the prime purpose. And there are other laws which have been added to the schedule, including Tamil Nadu reservation law, 69%. Otherwise, 50% is allowed, but Tamil Nadu allows 69%. Why? Because it's placed in the 9th schedule and judiciary cannot touch it. That's the general thing. But in the year 2017, what the Supreme Court said in the 9-judge bench, it's I.R. Coelho verdict, that even laws placed in the 9th schedule would not enjoy blanket immunity. It's not that you place a law in the 9th schedule and the judiciary cannot touch it. So it asserted its power of judicial review and said, even if you place any law in the 9th schedule, judiciary, constitutional courts, that is high courts and the Supreme Court, they can still scrutinize those laws and test their validity on touchstone of constitutional principles.
And just to add to that, the 9-judge bench very clearly stated that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th schedule.
So what you said is correct, and it was, the judgment was delivered by 9 judges. What is important is some of the things they said. First, the blanket immunity thing has become thing of the past. Second, they said, as Deepak has said, prospective overruling. Whatever was there till the Keswanan Bharti case, 24th of April 1973. Before that, if any law has been placed, so that would, but post that, any law, if it has not already been tested by the judiciary, if it's tested, they laid down twofold test. They said the law has, first the courts have to see whether the law in question violates fundamental rights or not, because there is a requirement under Article 13(2) that a state cannot make any law that violates Part 3, that is fundamental rights. And that is why 9th schedule was created, just to save it from getting hit by Article 13(2). So first, the Supreme Court said in the I.R. Coelho case in 2007 that first you have to see whether the law in question violates fundamental rights or not, that is Part 3 of the Constitution or not. If it does, then go to the second test. And second test is whether the violation also amounts to violation of basic structure of the Constitution or not. If answer to both these questions is in the affirmative, then the law in question must go. That's the test laid down by the Supreme Court 9-judge bench in I.R. Coelho case in 2007. Now, why the government has brought this law? In the first place, why we needed the SC/ST Act? Since 1950s, in fact, the Constitution of India itself was a sort of no less than a revolution. Many people say why India did not witness a revolution while we had so much discrimination against scheduled castes, scheduled tribes and other people. Despite that, India did not witness a revolution because the Constitution itself was a revolution. Without any bloodshed in one go, we gave right to equality to everybody. Untouchability abolished by the Constitution. So the Constitution itself was a revolution, but then on the ground, things did not change overnight. And that is why Parliament had to enact laws in the 50s, then in the 70s, and finally in 1989, this law. But there is a problem with the way Indian system, the state and the society reacts to things. We generally have a sort of knee-jerk reaction when either we are discriminating against the scheduled castes and scheduled tribes. When we try to protect them, we go overboard. The kind of provisions that were incorporated in the 1989 Act, many of them, and the case in which the Supreme Court delivered this verdict in March, even in that case, the Supreme Court noticed, and even the government admitted, that the law is being misused against government servants and innocent citizens, and there is no way it can be checked. And that is why the Supreme Court introduced certain checks and balances, and one of them was if there is a complaint against a public servant, he or she can be proceeded against only if there is a sanction or there is prima facie, the appointing authority has looked into it, and private citizens, SSP, has to look into it. So overboard we went and incorporated provisions which provided for arrest without bail, and anticipatory bail is not there. So many provisions were so harsh that the court had to intervene
and had to dilute it at the end of the day.
Now the question is whether the government should be overturning the Supreme Court verdict.
Okay, fair enough. Let me bring in the professor now, who's been patiently listening to both his panelists before him. Narendra Kumar, is this the right way forward? Is this the way we deal with the problem as far as the SC/ST Act is concerned, bringing it under the ambit of the 9th schedule?
I think Satyaprakash has told us about the history of this act, why we had to bring this act, particularly when we refer to Prevention of Atrocities Act 1989. Because in the original constitution, it was only Article 17, we said untouchability is abolished. So when it said that untouchability is abolished, but it was not actually abolished on the ground, and that's why in 1951 the Untouchability Offences Act was brought in. But what happened is, despite 50 Act of Untouchability Offences Act, there was not arrest of atrocities. In 1978 again, Protection of Civil Rights Act comes in. Then in 1989 the Prevention of Atrocities Act comes, and now after 20 years, I think in 2017 again there was amendment to this Prevention of Atrocities Act as well, because of the let's say pressure from the civil society organizations. And what actually is happening is, we need to look at that whether from 1950 to the present, whether atrocities have reduced or it have gone up. And when we look at the data itself, that is government data, not data by any civil society organization, and that's where it comes in very clearly that the atrocities are getting more and more day by day. These are multiplying, and these are not multiplying in one way. It's not now rural centric atrocities, but now there is, which is called something like very, very sophisticated kind of atrocities which keeps happening, let's say Rohit Vemula case and so many other institutional murdering which is called. So if that is happening and we have not been able to address this issue very appropriately, that's why probably now the government is thinking of bringing it in the 9th schedule. Then what I think is that though despite government bringing it in the 9th schedule, what will be happening? Whether the atrocities will be getting the low again, I am very much doubtful about that as well.
Okay.
Why? Because despite all these stringent act, atrocities could not be reduced. Another thing is that whether the FIR is lodged or not. See, most of the FIRs are not lodged. Let me tell you a very simple example. I was staying in Lucknow in a university, teaching in a university as a professor, and there was a theft in my house. I went to the police station and said that there was a theft in my house. Then the police station did not register my complaint. I had to approach the DSP saying that there has been theft in my house and there has to be, this complaint has to be lodged. And that's how this was lodged. You can understand that if a complaint, a simple complaint of theft is not being reported or lodged in a police station by a professor of a central university, then you can see that how a person coming from a very, very poor background from a rural area would be approaching the police, and the police will be addressing that question.
Sure, point taken. We'll try and discuss how to safeguard the rights of the Dalits probably a little ahead in the program and what needs to be done going forward. But before that, as far as the SC/ST Act is concerned, Sai, has the Act been misused? How do we prevent misuse in the Act? Is the dilution on part of the Supreme Court the best way to deal with the problem?
See, it's easy to actually load this particular issue by always assuming that the complainant is someone who is poor, uneducated and comes from a rural area. By doing so, we actually do injustice to the vast permutations and combinations in which these complaints are lodged, and the kind of circumstances and the kind of backgrounds people come from. Therefore, I don't think it helps to go down that particular path, because there is a decent chance that an educated, powerful, influential person could be the complainant, and the person who is the accused could be on the opposite end of the social spectrum, so you never know. Now, to answer your question specifically, the Supreme Court's judgment specifically takes note of statistics for the years 2015, 16, so on and so forth, and it comes to the categorical conclusion that there have been thousands of instances of withdrawal or acquittal in the cases that have been filed. They have turned out to be false in several instances. So, therefore, the Supreme Court...
The withdrawal can be argued also because of pressure put forth by...
It could be.
And that could be one of the reasons why the complaints have been withdrawn.
But see, therefore, since that point is made, it has to be understood that rise in the number of cases isn't equal to rise in the number of instances, but it's equal to the rise in the number of instances reported. Therefore, if there was previously a situation where people were not confident enough to come forward, and the legislation has given them the confidence that you can indeed come forward and a legitimate instance will be taken cognizance of, then that explains the rise in the number. Therefore, a rise in a number doesn't necessarily mean that there has been a rise in the number of instances that have happened. Because in a country like India, be it rape or any of these issues, they go unreported also, doesn't mean that they don't happen. So it's difficult to establish a correlation or a causality between the number of instances that actually take place and the number of instances which are actually reported. So that nothing much can be read about it. However, the Supreme Court's judgment is primarily based on the consideration of personal liberty of a person being affected as a consequence of anticipatory bail being denied as a matter of course in such instances, or one-sided complaints being entirely used and relied upon for prosecution, or the safeguards which are laid down in section 41 of the CRPC not being observed with respect to some of these instances. Therefore, what is it that the Supreme Court is trying to say? There is a legitimate interest or a legitimate grievance that is being protected by this particular legislation. At the same time, this needs to be balanced with its potential for abuse, where innocent people are sent behind bars or they suffer as under trials without ever having the safeguards that are otherwise available to other people. Therefore, what is the court saying? The presumption of innocence that is available in every other criminal case should be equally available to an accused as far as this particular case is concerned. And therefore, when it comes to grant of bail or observance of safeguards when it comes to arrest, have to be equally observed here.
Everyone is equal in the eyes of law.
Therefore, now the point is this. What does it mean? This particular legislation has not been diluted, but it has been balanced to ensure that fundamental rights and other rights which are available to any other person who is accused of any other crime is equally available to this particular person who is accused in this particular case. Now, what does this mean? Therefore, this legislation is being tested on the anvils of fundamental rights.
Right.
Therefore, if there is an aspect which violates fundamental rights, it violates basic structure. What does it mean? If it is put in the ninth schedule, it still doesn't change anything for the simple reason that if any provision of the legislation, even after being put in the ninth schedule, suffers from violation of Part 3 or fundamental rights or access to Article 32, which too has been recognized as a fundamental right, then such a legislation will still be open to judicial scrutiny, thanks to the Keshavananda Bharati case or thanks to the 2007 judgment. Therefore,
nine bench judgment.
Putting it in the ninth schedule, according to me, is meant for public consumption, and it's an exercise in image building for a certain establishment which wants to be seen as pro certain sections. However, in practice, on the ground, at least in paper, in law, there is going to be no consequence in terms of this legislation still being tested on the anvils of constitution at a later point of time.
Okay, the professor wants to take you on something. Yes, professor.
Yeah, I think, see, when we talk of that there has been misuse, there are no particular instances, there is no data actually. When we talk about the dowry instances, there was a data which was produced before the court, but in this case I don't think there is a data. And see, what basically the objective of this law was that there should be a fear before doing something, and that fear, we can say that all the people may not be knowing the law, but when we say, there was a controversy regarding this particular act, I think due to that in the rural areas also there is a significant knowledge about this particular act, that if you go and commit any atrocity against the Dalits, then you are going to be prosecuted in this particular manner. And see, if there is no data as such, and data also, what I would say is, if there is a data that let's say that how many people go for lodging the complaint, one. Second is that how many people get prosecuted, how many there are trials, how many there are evictions and all that. So if that is the case, then I think this judgment is primarily based on flimsy grounds. That's what my contention is.
One point of fact, if I may. On the aspect of data, The amicus report which was submitted before the court and which the court has relied upon clearly says 75% of the cases resulted in acquittal or withdrawal of charges. In 2016, 5,347 cases were found to be false out of the cases investigated with respect to SCs, and close to 1,000 cases with respect to STs. In 2015, 11,024 out of the 15,638 cases resulted in acquittal or discharge. 495 cases were withdrawn. So it's not as if the court has gone completely in vacuum without any data in its possession. And the data has been presented before the court by an amicus curiae appointed by the court.
Right.
So it's not
okay. So the court has taken everything into consideration, is what you're suggesting. Going forward now, let's take the discussion forward, Satya Prakash, because we've spent enough time on this. I want to go back to a point that Sai Deepak was making earlier. He said that if you bring the SC/ST Act under the ambit of the 9th schedule, nothing is going to change on the ground. It's just playing to the galleries. The government has been perceived, a perception has been created that it is anti-Dalit. Is it trying to shed that tag?
Of course it is. Of course it is. And it would not change anything on the ground in the sense placing a law in the 9th schedule is no more immune to judicial scrutiny. Post 2007 verdict, it can easily be scrutinized on the touchstone of fundamental rights and of course basic structure. I have already told you the twofold test. First, you have to see whether it violates fundamental rights, and second, if it does, whether it violates the basic structure of the constitution. But I am saying something else relating to this. Even if there was no data available, there was just one instance of violation of fundamental right, even then it is incumbent upon any constitutional court to provide for necessary safeguards, because the moment it becomes a question of fundamental rights of even one citizen,
fundamental rights trumps everything else at the end of the day. That's the bottom line.
And particularly the court on the last hearing, the court pointed out it's a question of Article 21, and which mandates post Menka Gandhi that each and every provision has to be fair, just and reasonable. Article 21 has to be read into all the provisions of any criminal law. So it's not a question of data being or thousands of people being subjected to misuse of this particular law. Even if there was just one person who has been subjected to misuse, the courts are duty bound to correct that. So that part, it becomes a question of constitutional issue. So courts are, but what is happening on the ground? The fact remains that SC, STs, they are being discriminated against. Many of such discriminations, I have witnessed it, and many of us have witnessed it. On the ground, the situation is not that good. The sad part is the so-called empowered people among the SCs, STs, they tend to misuse this law. And as Deepak has pointed out, in many cases, those who are misusing this law, they may be slightly well off than the so-called victims of misuse. So that is where it's a very tricky situation. It's not that everything is in black and white, that SC, STs are being discriminated against, and or that in all the cases the law is being misused against the so-called upper caste people. It's not that. In many cases, it's slightly complex, and there is a need to introduce safeguards. The court has tried to do it.
Sure.
I'm not sure how effective it will be, but then there is politics involved, and there are various. I'm not saying in democracy this is how everything works, but so far as law is concerned, generally what we do is we use law as a tool of social change and to take society in a particular direction. Here we saw that there is a section of the society which is being discriminated against, and over a period of centuries we tried to use it. First we brought that provision in the constitution which declared untouchability an offense, and then by using law as a tool we tried to tell the society, please don't do it.
Sure.
But then it has to be balanced.
Okay.
And that is why the courts have to intervene quite often.
Very quickly, sir, because we've got limited time. So, yeah.
Very quick points. Assume for a moment that there is one particular instance which has led to abuse. I agree with what Mr. Satya Prakash has said, but then it still doesn't show that there is a pattern which is the consequence of a structural infirmity. The data supports at least one thing, that there is structurally something problematic with the lack of safeguards as far as the SC/ST Act is concerned. And since this is a situation where it was not a case where one swallow makes a summer, the court comes to the conclusion that this data tells us that there is a problem, and these absence of safeguards are clear. Therefore, it is the absence of these safeguards that the court has actually tried to plug. Second, it's not a situation where fundamental rights are trumping something else. Now, this legislation of the SC/ST Act is a consequence of the intention under Section 17, which is also in Part 3. Similarly, fundamental freedom is also under Article 23, which is also in Part 3. Therefore, two sets of fundamental rights. One is to ensure that you are not subjected to casteist abuse, and the other that you are not thrown behind bars without any credible basis. Both these sets of interests and both these sets of competing rights, or let's say fundamental rights, are sought to be balanced by the Supreme Court.
Sure.
Therefore, the question is of prevention of abuse and striking a balance.
Right. Professor, as far as safeguarding the rights, safeguarding the interests of the Dalit community is concerned, what's the best way forward? Quick answer from you, please.
Best way forward, it's really difficult to say, because see, why there was a protest on 2nd April? See, it was not 2nd April, you know, on 2nd April
Yes.
there was, for the first time in the history of this country, there has been let's say organized protest all over the country, but not under any leadership, any political party or anyone else. So why was it? It was because of this only. Because when the discrimination is continuing, and you are saying that there has to be change in the law, which is stringent enough. So if that is the case, then in this particular case, it is really difficult to say that what is a particular mechanism. This was a mechanism wherein if you discriminate and the person who has been discriminated, whose rights have been violated, then he or she goes to the police station, then it will be taken care of. And that's where probably the people thought that there is something which is preventive in some way.
Okay.
Yeah.
From April 2nd, I'm going to bring you back to May 16th, Satyaprakash. I'm going to take you back to what the Supreme Court said on Wednesday. It said that it would not allow arrest of an innocent merely on a complaint, even if Parliament made a law. Does that mean we are going to see a major standoff between the government and the judiciary in the days to come?
Well, it's a clear-cut message to the legislature and the executive that even if you place it in the 9th schedule, it's not immune to judicial scrutiny. So indirectly, they have already said it. And this is broadly on the lines of whatever has been happening so far. And that is, there is a dichotomy in the thinking of the legislature and the executive on the one side and judiciary on the other side. The legislature, as late as 2015, if I remember it correctly, they amended this 1989 law, and to make it much more effective, provision for special courts, provisions for special public prosecutors, fast tracking of trials and all. So they are trying to strengthen the existing judicial mechanism so as to provide for speedy and speedy justice to scheduled castes and scheduled tribes who are victims of discrimination. On the other hand, the judiciary is saying whatever you have done, there are certain lacuna and it needs to be corrected, because it goes against certain basic tenets of constitution and certain basic provisions, including Article 21, and it needs to be balanced with the rights of common people. Quite often, many of them are put behind bar without being given due procedure.
Okay, quick concluding remark from your side before I close the show. I've got about 30 seconds remaining.
I think if we could address this issue from a legitimate standpoint of ensuring that those who are discriminated against need to be given access to speedy justice, at the same time this doesn't become a tool of persecution in the hands of those who want to settle private scores. As long as these two aspects can be addressed, dehorse the politics of it. While it's extremely difficult in a country like India, where there is a huge there is a huge manipulation involved as far as these issues are concerned. If we can try and address this, I think it addresses both sets of concerns.
Okay, on that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.